Good morning and hello to everyone out there in the listening, watching world. Welcome to another edition of The Legal Zone, where we tackle injustice. Good morning, John Salati.
Good morning, Salon Phillips. Glad to be back.
Good morning, Dr. Cheney.
Good morning.
Great to see you all today. Today we have a very special guest, and I'm going to get into that in a minute. But first, I want to talk about lawyers. Usually we start off with a particular law, but I want to talk about lawyers. There's so many of them. We know that. We've heard the lawyer jokes. We know about the lawyers in politics, and we know somewhat of what lawyers do. All lawyers are not the same. The thousands, maybe even millions of lawyers, even though they may all look alike and sound alike, and there's a reason for that. I know in my law school, they teach you how to write. They teach you how to talk or argue. To prepare you for a job, they teach you how to dress. They even teach you how to shake hands. So when you look at a lawyer, oftentimes you see something very similar amongst all of them. That's the name of the game. But not all lawyers are alike. Now, there's a rule, an ABA rule, Rule 101, that requires all lawyers to do the same thing. All lawyers have to be, one, knowledgeable in the subject in which they're representing you. All lawyers have to have some level of skill. All lawyers have to be thorough in their representation. And this is taken from the rules. So if you have a lawyer and you see that they're not doing one of these four things, you can call him or her out on it. The last thing they have to do is be prepared. So they have to be knowledgeable. They have to have some sort of skill, and usually that skill is already acquired through law school. They have to be thorough, and they have to be prepared. But again, not all lawyers are the same. And I'm not going to write out this Rule 101. Anyone could just Google it, Rules of Professional Responsibility 101.1. Today, we have a very special guest, and he epitomizes the above average lawyer. And I'm so grateful and thankful to have him on our show today. His name is Chaim Steinberger. Chaim Steinberger. Welcome, Mr. Steinberger.
My pleasure to be with you all.
Mr. Steinberger is one of the most elite attorneys in New York, if not the country. He's a family lawyer. He went to law school, like myself, later in life, and he graduated the top of his class. He worked for some of the most prestigious law firms after law school. Then he spent a year clerking for a federal judge. But he's human. And unlike so many people, during this time, he went through a very nasty divorce, very similar to myself. During this time, he said, there has to be a better way. Just as myself, he dedicated himself right then to practicing law that better way. He's authored articles and he's lectured on divorces without destruction, the perils of prenups, parental alienation, and how to win the unwinnable case. He's a mediator. He's an arbitrator. He is a litigator. He settles some of the most intractable cases, and he litigates ferociously those he cannot settle. He's been rated AV, which is the highest rating by his peers and colleagues. You can learn more about him or reach him at his website, www.manhattan-law.com. Again, www.manhattan-law.com. So all of our listeners who happen to be residing in New York, if you have a family matter case, and you've seen many of the cases that we've had here on the show, I encourage you to contact Mr. Chaim Steinberger. Now, Mr. Steinberger is here today with us to talk to us about one of his cases that was difficult, but he was able to have a favorable outcome for his client. So I'm going to turn it over to you now, Mr. Steinberger, and allow you to explain to us one of your special cases.
And before I do that, if you'll permit me, I have a page called Free New York Divorce Guides, and it's chock full of information for people who have different aspects of divorce or about an overview of the entire divorce process. And I also have a monograph, and I also have videos that I've done on exactly that subject of how to tell the mediocre lawyer, how to tell the great lawyer from the mediocre lawyer. So it's something I've been thinking about a lot. And particularly, I mean, those of us in the law, when we meet another lawyer, we hear a couple of words, how they start talking. I represented the colonel in the United States Army. And at one point, I told him, look, Colonel, all you have to do is watch how one of your soldiers withdraws a sidearm from the holster, and you already know if you can trust them with that campaign. And he goes, but of course. And so we pick up these nuances. But for somebody who's not schooled in the law, how can you tell? And I'm happy to speak to you about that, but I want to get back. I think you wanted me to talk about Tony's case.
Yeah, so just quick question. That website, is that just New York specific, or can anybody in the country go to that website?
Well, anybody in the country can go to the website. I caution people, I'm only qualified in New York. I only give opinions, and the articles are geared towards, so how to tell the superior lawyer from the mediocre lawyer. That's probably not only nationwide, but probably across the globe.
Okay, so it can be beneficial to anyone.
To anybody. Take a look at the lawyer's dedication, about their commitment. I boiled it down to three. Number one, smarts. The lawyer's got to be just downright smart. They have to know their stuff. And you might be able to tell when a lawyer hems and haws and hedges, or don't worry about it, or you don't have to ask me, or gets insulted when you ask them a question. Those are all signals that the lawyer might not know the answer and is too embarrassed to admit that they don't know the answer, which means that they have an ego issue. So somebody who knows their stuff can get up and say, I don't know, and that's fine. That's one of the best answers I can get from somebody. I don't know, I'll find out. So number one is smarts. Number two is commitment to the client, the dedication, the concern, the empathy for the client. And number three is creativity, because sometimes you have to think outside the box, and sometimes you have to do the unconventional to win the client's case. So if I had to summarize it for people out there, what are the three things that you as a layperson should pay attention to as you're interviewing lawyers? You can't open up a sheet and ask a magic question that when you get the answer to, I hear people ask me, are you involved in bar associations? And I laugh inwardly, because it's a great question, but you don't have the knowledge to evaluate the answer. Some people involved in bar associations don't know what they're doing, and some people involved in bar associations are cream of the crop. And so you can get an answer, you can get a trite, pithy answer, but you don't know how to evaluate it. So I'm advocating, look for smarts, look for the empathy and care for the client, and look for creativity. And if you see those things, then you're likely in good hands. So as you might notice, I've been collecting best books for the last 30 years, the best books on chess, on management, on flying, the best book on cross-examination, on trial practice. And so I try to bring all of those skills and professionalism down to the practice, and I love sharing this knowledge with others.
All right. So let's jump right into the case. One of your cases.
So I call this Tony story. I was the fourth lawyer on the case. The four other lawyers got shot down. I walked into court on an initial appearance on a motion to hold my client in contempt of court. The judge.
When you say shot down by the client or shot down by the court?
Shot down by the judge.
Okay.
Yeah. And I walk into court, and I'm looking for a brief adjournment because I was just retained a day or two before. Walk into court with a bit of a dramatic flair. You might be able to tell that I'm a bit of a ham and a performer. And I can talk more about that later if you wish. And the judge looks at me. This is one of the preeminent judges in Manhattan. In fact, she was the chief administrative judge for all matrimonial matters across the entire New York State. She really knew her stuff, top of the game. And she looks at me and she goes, "Counselor, you know your client's got 1 foot in Rikers, don't you?" And Rikers Island, as I don't know if it's as famous throughout the country as it is here in New York. It's a little island just to the west of LaGuardia Airport. It's a promontory off of Queens, and you have to take a bridge that would probably take you 10, 15 minutes to walk, and a small complex of about 15 buildings, all prison. Okay. And we're talking now about closing it down. It's a horrific place. And we could do a whole session on just that. And part of that is because it's only there for people who are serving less than 1 year sentences or being held until they're called in. So there's a large turnover, and it makes it for a particularly bad place to be. But anyway, judge tells me, "Counselor, you know your client's got 1 foot in Rikers." And I said, "Yes, I know that, Your Honor. I just need a brief adjournment, and then I'll come back and we'll argue the case." So that's the way we started off. The issue in the case, and forgive the guest appearance, the issue in the case, I have to give two prefaces to be able to explain it. Number one, in child support, if I assume, okay, you all look like you have some experience. You're not as young as most as Salon is, or some of the other people I come across. Back in the days of taxi cabs, okay, if you all remember, you'd get into a taxi cab, and the cab driver would drop the flag, and then you could drive around for 5 minutes, for 15 minutes, for 5 hours. You didn't pay. You didn't, every time you passed the block, you didn't throw in another nickel into the front or a quarter into the front seat. You'd wait until you got to the end of the ride, the flag would come up, and then you would pay the entire amount that's on the meter. Okay, so you have this concept of a flag dropping down, even though you only pay it then. The same thing is true by child support. Somebody makes a motion, either child support, spousal support. The moment they make the motion, and the question is it, most people interpret that the moment you file it in court, I think the better, and again, I'm being as picayune as I normally am, forgive me for it. It really should be not the moment they make it in court, but the moment they serve it on the opponent. So if there's a significant lag between the two, you've got a good argument that it doesn't go back. The statute technically says the date of filing. It should be the date of service. So the moment the person serves the motion for support, the flag drops down. It may take the judge 3 weeks, 3 months, 3 years to decide it. But when the judge decides it, it all goes retroactive back to the date of when it was filed. So that's one preface, this idea of a flag and retroactivity. The other preface I'd like to make is that when a court orders, let's say, dad to pay mom, let's pick a number, $500 a week, a month, let's call it $500 a month in child support. If dad gets little Joey and takes him out and buys him a pair of $300 Nike sneakers, dad can't deduct $300 for the sneakers off of the child support. You want to buy your son sneakers? God bless you, but it doesn't come off of the child support money. Mom gets the full measure of child support.
That's important to know. Can you tell the audience why that is?
That's because mom's got it. I say mom, forgive me, I'm using the typical gender. Sometimes it's reversed, of course, but it's easier if we use the typical. And I'm a throwback to a prior generation, and so forgive me for the genderism in there. But if mom has to be able to order her fare, she still needs to buy shoes and clothing and food and socks and school books and do all the things she needs to do. And dad doesn't get that right to be able to determine how the child support is spent. And if he goes out and makes a major purchase, maybe Joey didn't need it. Maybe he did. Now, if mom says, you know what, buy the shoes out of the child support money, that's something else. But he should probably get a receipt, because I'm a sneaky SOB and I don't trust people. Always get a receipt if that's what mom's saying. But dad can't just go and spend child support money and then take it off of her account. So that's a general rule.
Everyone make note of that. You cannot just spend money and try to substitute it for the court-ordered child support. Okay.
Right. And okay, so forgive me, the light. Okay. Now, okay, is this okay, the lighting?
Oh yeah, you're fine.
Okay. So with those two prefaces. Here's the deal. Here's the background of the story. So first of all, the procedural posture of the story when I came in. She asked, the father was running a cash business. She demanded to get the books and records. He claimed he didn't have any records. He wasn't the most organized guy in the world, and he didn't produce it. She made a motion to sanction him for not producing books and records. The judge granted that motion and therefore precluded him from putting on a defense. One of the sanctions that the court can either strike his pleadings or declare him in default. Instead, the judge ordered that he just can't put on his defense. And so when he shows up in court, he can't affirmatively put anything in. He can only cross-examine her witnesses. That was the sanction that he was. She moved to hold him in contempt of court for non-payment of child support. The judge referred that to a referee. The referee had already conducted a trial. At the trial, he was sanctioned. He could only cross-examine. He couldn't put on his affirmative defenses. The referee then issued a decision recommending that the court hold him in contempt of court. Not enough. This decision went up to the judge that we were talking about. The judge confirmed the referee's report. And now Mom made a motion to actually send him in jail. This is one of those tell your client to bring his toothbrush to court next time you show up moments.
And it was all because he didn't produce whatever documents?
Well, the sanction was because he didn't produce the documents. The contempt was for not paying child support. And so it was a conglomeration of things, but he was at the precipice. They had already prepared a cell for him with a big "Welcome Tony" sign outside the gates of Rikers for him. And that's when I came in. Now, here's the deal. Here's a little bit of the background story. When Tony and his wife split up, he said, look, I want to keep supporting the children. She said, that's okay. She went into the bank. She opened up a bank account. And every single workday, 5 days a week, Tony would go into the bank and deposit $200 a day into that account.
A day?
A day. $200 a day, $1,000 a week, $50,000 a year for child support. He's doing the right thing. Here's the wrinkle. When Mom set up the bank account, she set it up in one of the kids' names. And so every single time one of his prior lawyers came into court and said, Your Honor, he's paid child support, the judge would say, Counselor, you know that money you give to a child is not child support. You see now how things start to spiral around the toilet drain?
Right.
She walks into court and she goes, Your Honor, he walked out on us. The five of us are in the house. It's cold. We can't pay the heat and the electric. We're shutting off the light. We don't have any TV and cable. Oh, we don't know what's going to happen. We don't have it. We can't do it. The monster. And he's like, I've been paying. And one of his prior lawyers got up, the judge said something, Counselor, the money you give a child. He goes, Your Honor, you don't understand. And the judge goes, I don't understand. You don't understand. Motion denied. Bang.
Wow.
How to crack that nut. Now, a little bit more on the preface. Here's where it comes in. The moment she served him with the formal legal divorce papers, he stopped putting in the $200 a day. Right? She made a motion for child support, for spousal support, for all the other things. Now it goes through the support collection unit. Now it's all done very formal and legalistic. He stopped making it. But the overlap between when she made the motion and when she served him with the motion was 2 days. 2 days that he had deposited $200 a day into the account because he didn't know this action was pending. And so now that there's an action pending, if I'm right, if this counts as child support, he's entitled to a $400 credit for the 2 days' money that he put in.
Right.
So the dollar value of the issue is $400.
That's the amount he was going to go to jail for?
The overlap. No, the overlap. In other words, once he's out, once he got the order, he was paying her directly, and that was happening. And then the question was, how much does he make? Is he paying enough? And so, and I don't recall exactly what the contempt of court was, and so it may have been, but the amount of child support that overlapped from when she made the motion to when he stopped putting in money was $400. If the money that went into that account was child support money, he's entitled to a $400 credit. So it's a $400 issue. The prior lawyer said $400. In the big scheme of things, it doesn't matter. However, the narrative. So probably the most important thing, and I tell you, I've been collecting the best books. I'll share this with the lawyers out there. The best book I've ever found on trial practice was written by the late Judge Ralph Adam Fine, called The How to Win Trial Manual. I think it's a juris publication. The How to Win Trial Manual. And he and others also say the most important thing in a trial is the theory of the case. Generally speaking, one side has a theory, the other side has another theory. One side says the doctor was incompetent. The other side says he's a good doctor and bad results happen in medicine. Every side has an argument. I also serve sometimes as a volunteer judge arbitrator in small claims court. And I am amazed. Nobody ever walks into the courtroom when I'm presiding. Nobody ever comes in where one side is right and the other side is wrong. Each side in their own mind, according to their narrative, they are right. And the question becomes, as between this one who's right and that one who's right, which one should win? So it's not usually right and wrong. It's right and righter, and that becomes. So the question becomes, how do I deal with, and of course, every one of these topics we can spend hours talking about. So forgive me, I'm not doing it justice, as it were. How do I tackle this? And I looked at Tony and I said, the only way to turn this case around is if we go back to the underlying issue and we prove that I don't remember, half a year, so let's say we said $50,000 a year, maybe $30,000 that he had put into this account, that this money went to her, because that turns you from being a louse who abandoned his family out in the cold to being a good person. Okay. And I said, it's going to be long, it's going to be expensive, because there's a lot of background work that has to be done. We ended up spending $60,000 to put the documents together, again, to protect $400. But it wasn't really the $400. I told him, look, it's not the $400 I'm aiming for. I'm saying as long as you don't get the stench off of you, you won't make any traction. You won't have any traction in front of this judge. We need to get the stench off of you, no matter what it costs. He agreed. We did that. I show up in court and I say the same thing. And the judge looks at me and goes, counselor, you know that money you give a child doesn't count toward child support. And instead of saying, no, Your Honor, or you don't understand, Your Honor, I said, you're absolutely right, Your Honor, in a normal case, not when mom opened up the account and has been using the money. And the judge goes, how do you know she's been using the money? And I go, well, Your Honor, I gave you a booklet with exhibits. Exhibit A has tab A has the $30,000 and where the money went to. So $10,000 went to Neiman Marcus for dresses, and $5,000 went for family electrical bills, and $3,000 was taken out at her brother's company, the ATM at her brother's place. And the judge goes, how do you know? Well, each one had a tab, had an exhibit. It was about yay thick, and we accounted for every single, for most of the money that went in there. And I said, look, The son is going to college and so. Unless he's got a cross-dressing fetish that we don't know about, he's not buying dresses at Neiman Marcus. And so that changed the entire dynamic in the courtroom. Now, aside from that, I had the technical argument. There's a rule in New York State that says if you win a motion, and the judge says this may be particular to New York, here in New York, judges generally, many times, judges don't write their own orders. They tell the lawyer, settle an order on notice. And it's up to us lawyers to draft the order. On notice means the other side sees it as I submit it. Please take notice. I'm submitting this order to the court. There's a rule that says I have to do that within 60 days. And just recently, before I argued this, like half a year before, the appellate division had come out with a rule that if you don't comply with that 60-day argument, you forfeited it. And so even though the judge had confirmed the contempt finding against them, I say, Your Honor, under the case of Farkas v. Farkas, they forfeited it. You can't throw them in jail. But I said, so here's the 1-2. This goes back to the theory of the case. I could have gotten up and just said, Your Honor, I've got a technical argument. But the judge would still want to throw the book at him. I needed to change the judge's heart, mind, body, and soul, where the judge says, you know what, throwing him in jail would not have been fair. And now here's a technical argument why you can't throw him in jail. And that combination. And then I said, Your Honor, so you asked me before about the contempt. I said, Your Honor, you know what she does? The court had ordered him before to send checks. He wasn't, as I said earlier, he wasn't a great bookkeeper. So he started to send the check, and he would send it certified mail return receipt requested. And the mailman would come to her house. And so I tell the judge, I say, Your Honor, this is a type of woman who, when the mailman comes and rings the bell, she tells her kids, we're going to play a trick on the mailman. Let's make believe we're not home. And the mailman rings and rings and rings, and she doesn't take the child support check. And it goes back, and the same thing over the course of 3 or 4 or 5 days. And a week or two later, she goes to the post office, she picks up the check, she tries to cash it. By that point, the man's running a cash business, right, wrong, or indifferent. By that point, there's not enough funds in the account, and the check bounces, and she comes running back to court. You see, Your Honor, he gave me a bounced check for child support. And that's where the contempt comes in.
How much total was the judge saying that he owed in child support?
I don't recall. This was a couple of years back. I don't remember the number, but this had built up. As you can tell, this was the accretion of the bad stuff the judge believed he did over and over and over. And the judge said, pay. And there were a couple of these checks that she had bounced. And so the judge was convinced that he was a slime ball.
And I'm assuming that the ex-wife's attorney was helping to paint that picture in the judge's mind.
Well, affirmatively did that, and his lawyers didn't have the ammunition with which. I said, Your Honor, let me tell you what type of woman she is. The kids come to visit him, and they go back to her house. And the oldest kid was a bit of a wise guy, and as he sees what's about to go down, he butt dials his father. So my guy's hearing all of this on the phone. Mother comes over to the oldest one and says, where were you? Where were you? You were at your father's, right? Right. He goes, no, I wouldn't be caught dead at that son of a bitch. I hate him. I'm not going. And so she turns to the second kid, who's a bit of a straight shooter, and she goes, you can't lie to me. Tell me the truth. You were at your father's. And he goes, yeah, we were at the father's. And she goes, whack. My guy hears it on the phone, how she whacks the kid. I say, Your Honor, this is the type of woman that does it. And the judge went white. Her face fell. And when she gets off the bench, she goes, wow, this case gets more and more complicated. She was sure that the mom was the white knight, and that my guy was Dr. Evil. And in that one, we had a 2-hour oral argument in front of the judge. He had to spend more money than he should have, but we turned the judge's head around. He went from 1 foot in Rikers to being vindicated as being the right guy who's done things right. Okay, he didn't keep his books right. He didn't have the paperwork. He didn't do it. He was a bit of a wheeler dealer, but he did try to do the right thing.
Wow. Okay, before I turn it over to Dr. Cheney, I just want to know, Why do you think, or what do you think the reason was these other attorneys? You said there was three or four attorneys before you. What was up with them?
So it takes a certain amount of, I don't know, how do you tell a client to spend $60,000 to defend a $400 issue? It was $400. And by the way, I didn't know up front how much it would cost. First of all, there were like a million motions, and we had to go through the motions and figure out which papers belonged to which. And then we had to go through and get the records for the bank accounts and where the money came in, where the money went out, and do all of this accounting work. This was a lot of work, a lot of detail-oriented work. Many lawyers are not that detail-oriented. Many lawyers don't really know the law. Many lawyers are like, well, I guess the judge said that you can't take it as child support. And they'll just accept it as being the word of the law. And it's understanding the judge and what parts of what the judge said, why the judge thought she was right. And she was, for the general part. I mean, I don't disagree with her as a general proposition of law, but in this case, it didn't apply.
And to be clear, you said that it was $60,000 for $400, but it was actually his freedom. It was more than just $400, right?
Absolutely.
Okay.
Absolutely. And a lot more coming down the pike, because the case was going to go on for a while. And she claimed that he's rolling in millions and she's destitute. And so it would play out in the equitable distribution, the child support, and the maintenance. It would play out in a million different ways.
And how many kids were there?
5, I think.
5 kids. Dr. Cheney.
Okay. Welcome, Attorney Steinberger.
My pleasure. Nice to be here with you.
Okay. I want you to share with us or refresh me on this bank account thing. If I'm going to go and deposit money into a bank account, wouldn't I know the name on the account?
Possibly not. Back in the old days, all you need to do is have the account number. When you go in, you pull out a deposit slip and you fill it out and you put it in. But even if he knew it was his son's bank account, he didn't think anything of it. That's where she told him to deposit the child support. So he did.
Okay. So the other part is, I am such a layperson, and you 3 guys are the experts in this. And I want to share a little verbiage, and then I'm going to get into 3 quick questions, okay? Former South Carolina Congressman Trey Gowdy, who returned to his legal career, was often seen in the media talking about Lady Justice. As I said, I'm a layperson. That was news to me. I said Lady Justice. So Lady Justice symbolizes the foundation of our legal system in America, and I'm told in various places across the world. She has 3.
I think we inherited that from England. When we declared our independence in 1776, we took the body of law that we were operating under, that we got from English rule, and then we broke off and built on that. So a lot of our legal system is premised on, except for Louisiana, which continues under French law.
She has 3 attributes: blindfolded, holding the scales of justice in one hand, and a double-edged sword down in the other hand. So you can help me with this. The blindfold represents impartiality. The idea that justice should be applied without regard to wealth, power, or other status. The set of scales represent weighing the facts of both sides of an issue. The sword is to show swift justice, punishment for doing wrong, evil. Gowdy goes on to say, when our fellow citizens think we have a 2-track justice system, either for the famous or not famous, or rich or the poor, we're in trouble as a republic. Attorney Steinberger, my question is, will you tell us about your views on Lady Justice and regarding your client?
In this particular case or in general?
In general, if you want to.
Okay. So I am a believer in the legal system. As I said, I clerked for a very wise, compassionate, and super brilliant jurist appointed by the President of the United States with the advice and consent of the Senate. Back in the day, that presidents were careful whom they appointed to the bench. None of these 3-year-old lawyers appointed to the bench stuff that we recently saw. And so the federal bench and bar, for example, is considered to be way far and beyond above the state court system. And we've got a pretty good state court system. I belong to more bar associations than I probably should. I'm overcommitted. And many of us strive and work hard every day to make the system better and better. Notwithstanding that, things can go awry. I liken it to somebody taking a tour of the Big Ben clock tower in London, and you're walking inside and watching the mechanism and awed by the intricacies of the mechanism, and you walk by and a sleeve of your jacket and because of that sleeve drags the whole person in, and now they come out a bloody pulp. There's the rule on Wall Street is that on Wall Street, sometimes the bears make money, sometimes the bulls make money, but pigs always get slaughtered. So people who approach the legal system and approach the judge and say, look, here's what happened. I did this, the other person did that. Tell us what the right resolution is. Usually they will get justice, with the understanding that justice is not one point on the scale, it's a range, anywhere here. So we say in law school, reasonable people can disagree about what the right result is. And reasonable people can disagree about what a reasonable result is. But generally speaking, if you go in, you will get a fair result. And it's the people who try to outwit, oh, I'm going to play this, I'll tell them this when that happened. And once you start playing, once you introduce a false statement, or you've got crooked tax returns, and now you come into court. Now, well, what do? Do you tell the truth, but then you can get caught up with your tax returns, or do you lie now, and now you're lying again, and you're compounding there, and now you're in this catch-22. So as a general matter, I believe in the legal system, and most of the laws are well thought out, and the judges try to do the right thing. That's not to say I was talking to Salon before. I have a list of, I call it Tales of the Crypt, horror stories from the courtroom. And so sometimes things go awry. And sometimes you have to go up to the appellate division to correct it. And sometimes there's a political, but this is, I'm going to give and take away at the same hand. If there's a political implication to the question that you're posing to the court, the lawyer should have a long discussion with the client about the politics of the situation, and you should game that out. So for, what do I say? Okay, let me give you an example. 40 years ago, maybe a father wouldn't pay child support. A year, 2 years, 3 years of child support would add up. Mom would be going crazy. She can't feed the children. Finally, she goes back into court and she says, Your Honor, he owes me $12,362. And the judge wisely turns to the husband and say, You owe child support? And he goes, Your Honor, last Christmas, she didn't let me see Joey. And the judge goes, You didn't let the father see Joey on Christmas? That's it. All of the child support is wiped out. And because that happened too many times, New York State legislature passed a law that says that once child support arrears have accrued, they can't be wiped out. Now, what do you do to somebody who loses his job? He figures he'll get a job in another week or two because I'm a great guy, and he lost his job. He goes out to that night with his buddies to the bar and has a round of drinks. But it doesn't take a week or two. It takes a month or 2 or 3. And keeping up with your child support is hard enough when you're making the money. Suppose now he gets a job that's paying less. He now still has to pay child support, but now he has to pay the child support arrears that have accrued during this period of time that he hasn't done it. And once it's accrued, it can't be wiped out. And so what I try to go around, I've been writing about this and talking about this, if you have a child support order against you, you get laid off from your job, your first order of business is to go into family court and make a motion for downward modification. It may not get heard and decided for 3 or 6 or 9 months, but like we said earlier, the flag drops. And then whenever it happens, the judge can go back and make the adjustment that's appropriate, because otherwise you're going to get killed.
And that's in every state. So if you have a change in your circumstance for child support, make sure you file that motion to modify child support.
Make sure, even though we all hope that you're going to get a better job that'll pay more and you'll get it quickly and it won't last long. But the first thing you need to do is make sure you protect the downside, because it's going to be hard enough to pay the child support without paying double child support every week and still putting on a clean shirt to go to work the next day. So the all of law is like a seesaw. So, for example, we all believe in freedom of speech. That's one of our principles. We all believe that the New York Times shouldn't be able to go around and just write anything about you and make up a story that you've had an affair and cheated on your spouse. So we believe in libel and slander. The problem is libel and slander is in tension with freedom of speech. So the stronger the libel and slander laws become, the weaker free speech is. The stronger free speech is, the weaker libel and slander is. And so whenever I go into court as a litigator, I need to understand what's on the other side of the seesaw, and I need to game out my litigation strategy in order to get there. But the system as a whole should work. Now, with all of that being said, and I believe that to my core, the world has been crazy for the last couple of years. We elected a scoundrel to be the president. How do we intend to run a country when the chief executive says, I cheat on my taxes? And so how's anybody going to pay taxes without feeling like a rube for paying? And then how do we pay our military and police and fire and everything else? And then he's appointed incompetents. And we all know that these are people who they have a certain party line and they're appointed. And of course, the videos that we keep seeing of people in minority communities being mistreated, where the police don't have respect for the people. They seem like they're an occupying power instead of serve and protect. Those are problems that we need to deal with. So
it goes to a theme that we have on this show, is not the system is not so much corrupt, it's the people placed in charge of running the system that tend to be corrupt.
And it may be, shall we use the word implicit bias, and the biases come in and they perpetuate, and they can come down maybe in subtle or non so subtle ways. And so we all have an obligation, those of us who are committed to justice and law and order and fairness, we need to see it, to recognize it, and do our utmost to create a fair and honorable society.
All right, Dr. Cheney, one more.
Do you think, Attorney Steinberger, do you think your client or any of your clients felt an erosion in the confidence in our American judicial system?
So I am unusual because I guess my mother didn't talk a whole lot about this. My mother was both my parents were Holocaust survivors. My mother was in Auschwitz. 3 times she was sent to the gas chambers, and each time she managed to get out of the line for the gas chambers, and she got herself onto a slave labor camp where she worked and survived the war. And so this idea of I had a law school professor who used to say, sometimes you just have to mount the insurmountable wall. And so how do you make this happen? How do you get the system to do the right thing? That can be very difficult. And not everybody has the perseverance, and not everybody has the tolerance to be able to do it. I've had one client, I had a father who had the children for the majority of the time, but his wife threw him out of the house, and she screamed at him from the second story window, "You don't live here anymore. You're not part of this family," and changed the locks on the door. So he was living elsewhere. He had the children about 60% of the time. We show up in court, and the judge says, wait, what I want to know is your client paying child support? And I say, no, Your Honor, he's not paying child support, but he's not receiving child support. And she goes, receiving? Why should he be receiving child support? I said, because he has the children 60% of the time. And she goes, but. I almost felt like she was saying, but he's a man. What do you mean? She's still living at home. She must be the custodial parent. And this went on time after time after time. She did a couple of other things that I had her, and I went ahead and I made an 800-page motion for her to recuse herself off the case. Wow. Now, I don't know if you know my friend Niccolo from Florence, Niccolo Machiavelli, who says that if you're going to try to assassinate the monarch, you had better succeed on the first attempt, because you don't get a second attempt. Right. And I walked back into court, and the judge was mocking my motion, and she read passages to opposing counsel to mock me. And she set the return date, the date that we would show up to argue it, for a couple of, I think, 2.5 months later. And then well before we ever got there, that motion granted in its entirety, and she recused herself off the case. So I can understand sometimes people are disenchanted with the legal system. What the Fifth Circuit did when Judge Pittman on Friday or Thursday, was it, when he reversed and he said SB 8, the Senate Bill 8, that put bounty hunting on for people who got abortions. And Judge Pittman said this is unconstitutional. It violates the law of the land, which right now Roe v. Wade is the law of the land. And therefore, I'm putting a stay on it. And then went up to the Fifth Circuit without any decision, without any reasoning. He put in a 113-page decision explaining what his reasoning is, and they put a stay on it. And I think arguments for it is going to be this coming Tuesday. So I'll just note we're recording this on October 10th, 2021. In another couple of days, the landscape may change. So I'm not saying everybody all the time. I've lost great respect for our United States Supreme Court. They used to be impartial, but when they decided a couple of years back that a 40-foot cross on public property, that's not a religious symbol, and extreme gerrymandering, oh, that's too complicated, we can't get involved, we'll leave that for the politicians. That's like, wait a second, that's not calling it fairly. Chief Justice Roberts, when he was put on, he says, we just call balls and strikes. He's not doing balls and strikes. The court isn't doing balls and strikes.
That's a topic for a show in and of itself. John, do you want to give Mr. Steinberger any final thoughts before?
Chaim is fine. You don't have to be formal with me.
Chaim, okay.
As you wish.
Well, Chaim, in that case, since you've opened that door, I playing off of something Dr. Cheney was saying, the issue of, well, the two things that have...
I'm having a little bit of difficulty hearing you.
John. All right, the issue that we talk about all the time at the Legal Zone is, where is the injustice? And there are two things that have come out of your remarks. One is the competence of counsel, because the story that you laid before us, where there are 4 lawyers, right, end up representing this one person.
If I may, I wouldn't just call competence. I don't have any argument with the competence of the 4 prior lawyers. This isn't the case where they fell asleep at the wheel. So I want to distinguish between barely competent, an okay lawyer, but a really savvy lawyer. Nobody else, that motion, an 800-page motion to have a judge recused, nobody else would have done it. It sent tremors through the entire courthouse that, like, oh my God, Chaim did it again. And so, but sometimes you just have to mount an insurmountable wall. I thought long and hard about it. I gave my client a significant discount for it. I said, look, the system hasn't worked for you. I know that I can't work for free, but I'll give you a significant discount and I'll do this for you. But this is my commitment to justice. But 95 out of 100 lawyers would not have done that. So I don't want to make it seem like this is just competence. Forgive me, I didn't mean to interrupt.
Well, I take your point. Indeed, I was going to say, I'm not even going as far as saying they were incompetent in that legal sense of the term, but just that the quality of counsel that many people have available to them makes such a difference. How do you work the system, even if, as we go under the understanding here, that the system in and of itself is a solid and good thing, but it is so big and so complex that unless you have a higher than average level of ability, let's leave the competence word aside, that client is going to be in a tough situation. The other side of that is also the money. That is, we all have encountered clients, or let's say people who we've had on the show, who have little or no resources. And so now, how do they manage to get any kind of justice where you can't get counsel who are willing to be, who have the higher than average level of ability, and who therefore cost more, because that's the way it goes. That's capitalism at its best.
Or if Tony hadn't had the $60,000, he may still be in Rikers today, and I know that. So,
and that's just one motion.
And that's just one motion. And I mean, that's it, but it went to the heart of the matter. But I've been troubled by this thought for a while. I told you I'm involved in a lot of bar associations. So I belong in the New York State Bar Association. It was called the Task Force on Family Courts. Now it's morphed into a permanent committee on families in the law. And we talk about family court, at least conceptually and theoretically, is designed for people to be able to represent themselves. But I don't know. I've got a 20-page monograph on my free New York divorce guides with a title of "So You Think You Don't Need a Lawyer," and how even good, really top-notch lawyers, when they went in to represent themselves in their own divorces, got really screwed up. You know that we lawyers have this old adage: any lawyer who represents himself has a fool for a client. And so and I was in family court once waiting for my case to be heard. So as I usually do, I'll go into the courtroom and just sit around and watch the judge and get a sense for the judge. And I hear somebody making an argument, and the man says ABC, and the judge says something about XYZ, and the judge gives an adjournment, and I realize this man did not understand what just went out. And so I figured I'll do my good deed for the 2020s, and I stand outside and I wait for him to come out. The case is over. He comes out. I say, "Would you like to know what just happened?" He's like, "Who are you?" And I said, "Nothing. I'm just a lawyer, disinterested. I don't have any dog in the game. But it occurs to me that you likely didn't understand what was going on. I'm happy to explain it to you if you'd like me to." And he goes, "Well, what do you want?" Somewhat wary and skeptical. I say, "Well, here's what you said. You said ABC. ABC is not a legally valid argument, but you came really close to making a good argument, a legally valid argument, which was X, Y, and Z. That would win the day if you were able to prove X, Y, and Z." So what the judge did was the judge said, "You know what? I'll give you a 30-day adjournment. You can get your evidence for X, Y, and Z, and you can come back." And he's like, "Oh," it all sort of clicked in and made sense. When you have people, support magistrates, for example, they have, 300 cases, at least here in New York. They have 300 cases a day. They've got 3 hours in the morning, 3 hours in the afternoon. That gives them exactly 2.3 seconds per case. I'm making a sophisticated argument, and I see the judge working the calculator. And so I'll stop talking. He's like, go on. I'm listening. It's like, who was it? On 60 Minutes, I'm forgetting his name right now. The guy who said, "What kids today call multitasking, our mothers used to call not paying attention." And it's like, if I'm making a sophisticated argument and you're playing the calculator, you're not hearing me. So I'm troubled by that. This stuff really is complicated. And when we talk about theory of the case, the example I give for clients. So let's say I don't do medical malpractice work, but let's say a client was injured by an operation. And so you've got to think about what is the theme that you're going to use. Is the doctor incompetent? Well, we could do that. And then if we get the jury to buy it, maybe the jury will award us damages. But if this doctor has won accolades from all of his friends and he's got high marks and high degrees, we can't do that. However, if we know this was the last operation of the day, and we know he had an affair with somebody and he wanted to be finished with this operation, with this procedure, in order for him to get out and see his paramour before he had to be home. Now, all of a sudden, the moment you introduce that, all of a sudden people go, oh, yeah, okay, yeah, that works. But you have to figure out the theory of the case. All of this requires time and effort and energy. Somebody will call me up for a quick question, and you start to talk about it. An hour and a half later, you come up with insights as you turn. I liken this to a crystal glass where the sun shines in. There's a beautiful pattern. But if you turn the glass just a little bit, the entire pattern changes. So good lawyers never lie, but we spin the facts in a way to present to make our clients look good. But it requires dedication, strategy, tactics, game theory, Sun Tzu, the art of war. All of this comes into play. And now here's the deal. I talk about this in my lecture, The Perils of Prenups, how avoiding the psychological imperatives that make good people fight viciously. Because people don't always fight because they're malicious. They fight because they don't have a choice. Here's the deal. When we feel threatened, we get tunnel vision. And we only see this as a defense mechanism, so that when we hear the rustling and the amygdala thinks that it's a saber-toothed tiger, it says, forget about your damn exams and forget about the mortgage. You need to get out of here. You need to save your skin from the saber-toothed tiger. Unfortunately, though, that gets triggered when we're feeling anxious and afraid because we're in a lawsuit. So the most important thing I can do as an advocate, as a lawyer, is to make my client feel safe. If the client feels safe, they get some broader vision. How do you do all of this without the client, for the clients who don't have money? And I don't know how. I don't have the answer. I wish there was. In the tax force and family courts, we're talking about what is it called? Not flat fee billing, but to break it up and say, I'll only represent you for this, or I'll only draft.
Not the contingency.
Not contingency, because that would be
allowed, right.
That would not be allowed in family law. But to limited scope representation. I'll just draft the papers for you. But the papers you're drafting are connected to everything else. You need to know everything about the case, and it needs to tie into the strategy, and you need to get up and be able. I've had people tell me, Chaim, you're a brilliant lawyer, but I can't afford you. Why don't you come up with a strategy of the case? And then I've got this kid who just graduated law school, and we'll let him get up and do it. And it's not like I keep saying the practice of law is not arithmetic. You can't pipe up and go 2 + 2, Your Honor, and the judge goes 4, of course. It's like chess. If you make the same move one step too early or one step too late, it can cost you the game. If you make it at the right time, it can win you the game. So how do we do all of this? How do we give this to people who don't have? And I get that it's expensive, and people who are making 30 or 40 or 50. Nobody ever makes. Everybody is making just enough money to support themselves and their family. Nobody ever has enough money to split their family into two, pay for the 2 families, and pay for 2 sets of lawyers and their children on top of it. How do we do that? And I'm troubled by that, and I don't have a good resolution.
And therein may be the injustice that John is hinting to, that people have these big problems, but they don't have the big money to solve them.
I wouldn't call it an injustice. It's a problem. It's a problem for society, the inequality in society, when somebody can fly up to space and other people don't have bread to eat. Now, during the pandemic, I've seen food lines in my middle-class neighborhood that I've never seen, where it used to be the differential between the line worker and the CEO was 40 times, and now it's 40,000 times. I mean, we have a problem. The reason I was told by a lawyer, I don't know this myself, is that the estate tax came in because of the robber barons and because people saw that society was not going to last. We have a foundational problem in the country where we have a huge inequality, and if we don't solve that, the country's going to tear itself apart. We see the stresses right now. And unfortunately, the Republicans stopped being partners in governing. The Democrats believe that governing is a good thing and government can solve problems. And the Republicans just want to say government is no good. We need to dismantle government. I mean, how can you be a partner with somebody? How can you? It's one thing if you're rowing and you're not rowing in time. It's one thing if you're rowing and your partner's rowing in the opposite direction. And it's even worse if you're rowing and your partner's drilling a hole in the bottom of the boat. And how do you do that? And it seems like they're no longer, they had an insurrection and it doesn't seem to bother them. That's okay. We'll blow it off. What are you making a big deal about it? So I tried to kill you. That's okay. Why can't we move past that?
And that's another show, a new topic for that conversation. We could talk about that all day. Chaim, it's been a pleasure speaking to you. We can go on for hours. We've already passed our time. Thank you so much for coming on today. Everyone out there, again, the website is www.manhattan-law.com in New York. But he also has a website. What was that other website with the free information?
It's a subdivision.
Oh,
On manhattanlaw.com, there's resources for divorcing people, and there's free New York divorce guides.
Check out the resources on that webpage. You would have all the information you need. You'll be knowledgeable, not enough to represent yourself, but you at least have some knowledge that could help you. Thank you again, Chaim, and we will talk to you later. I'll be sure and keep in touch with you.
It was my pleasure being with you. I hope you're able to help other people with all of this information.
Yes, thank you so much.
Okay, bye. Pleasure meeting both of you as well.
All right. All righty. So, John, final thoughts, and come up close because your mic is kind of low.
Well, I mean, I think I would take a little issue. It's a splitting hairs moment. Chaim's point about inequality is correct, but I would say inequality leads to injustice. Those are things just like, leads to hunger, it leads to this, it leads to that. If the scales, right, you talked about the scales of justice and all that, the problem is, is the blindfold really there, or is it kind of, tweaked to the side and it's not so blind, or the scales already have a thumb on them so that they're already pre-weighted in a way? That's inequality. Inequality leads to injustice.
And I wonder with the money issue, I mean, we know that people have doctors' surgeries cost tons of money, but there's insurance that people who may not have that money could cover. Is it possible to where people can have the same sort of insurance access for lawyers, where they can say they get a certain amount of money for the lawyer of their choosing? And is that an option that the government is just choosing not to exercise?
Well, clearly the government doesn't do that. I have actually heard of such thing. There is legal insurance, but I doubt it would cover the kind of things that Chaim was just talking about.
Yeah, the legal insurance that I'm aware of, it's more so you pay this flat fee and then there's a pool of lawyers that they would go and they'll represent you in certain cases. But the pool of lawyers, those are the lawyers that you have to choose from. And usually technically they're not the greatest because the price is so low. But what I'm talking about is they give you a $10,000, $20,000 check and they say, here, go get whatever lawyer you need, because that could be the average retainer. So maybe if that option is available, but the people in charge is just not making it available, then that could possibly be an injustice. Dr. Cheney, what thoughts do you have to take away from all this?
Well, it's a very interesting and informative interaction, but I still stick with the idea that Gowdy is right when he talks about the two-track justice system, for the famous or the not so famous or the rich or the poor. We're in trouble. And I think that exists, especially with people that don't have the cash. But
So you're leaning on it that there's justice out there, but if you don't have the money to get the justice, you're screwed, basically.
right, unless you are not, if you're over income, meaning that you would not be public housing or that kind of financial
And there are systems for that. They have the tons
legal
of
aid. Yeah.
legal aid, and then a lot of large law firms, they do these pro bono hours. So they do take cases, but unfortunately, there are not enough of them where they can take every case. So there's still people who could not afford a good attorney, and they just go in there either with their aunt and their uncle who went to law school, and they don't really know the law. They don't have those attributes that Chaim talked about, and so they just don't get the right representation.
Well, with the pro bono, are they dealing only with people with a certain income level?
Some they do, but others no. Others pro bonos. When I was at a firm, we did pro bono. It was just a case, and it's up to the partner whether or not they're going to take it pro bono. But usually, it does have to do with a money thing. They want to see your income, and they want to make sure you can't afford a lawyer outside of that. All righty. Very interesting show. Thank you all for watching. Don't forget to subscribe to the button on the bottom. Continue with your comments. Send to Remus Law, info@remuslaw.com, I think it is. Our producer would put the email address down at the bottom of the screen. Thank you all, and we will see you next week. Thank you, John. Thank you, Dr. Cheney.
Okay, bye-bye.
Have a good one.
Thanks for watching our video. For experienced legal services in Washington, D.C., Alabama, and Washington State, visit our website at remuslaw.com or call us at 1-833-329-1799.
When someone goes through a divorce, they lose their best friend. They lose their house. They lose their children. Any time away from your child is a loss. Let's face it, divorce kills. The average cost in the United States for a divorce is $13,000. It's not uncommon for a divorce to cost well into the hundreds of thousands of dollars. At Remus, we take into consideration you, the divorcing spouse, your property, your money, and your children. We assist clients in directing them to therapy, mentorship programs, savings. We mitigate the cost of divorce to keep your expenses down. We look out for the client holistically.
I came to Remus Law seeking a divorce. Salon listened to me. I told him my story. When he mailed me a copy of the complaint, which summarized my story, he was able to say exactly what I had been feeling for so many years. When my husband was served with the complaint, he came to me with tears in his eyes. He said he didn't know this is how I was really feeling. He asked if we could try again.
At Remus, we do all that we can for our clients.
Wait a little bit longer. Wait a little, we'll be coming around again. 'Cause you know we're stronger than we were when you and I began. I don't know what's harder, holding on or letting go. I don't know if we oughta, know if we oughta, know I know. I don't know where we're going, but I know it's gonna be good. I don't know where we're going, but I know it's gonna be good.
The lessons taught in the adventures of Uncle Billy and Ross are lesson that adults learn late in life. Some never learn it. I will recommend every parent, every young person, every adult read this book. But more importantly, apply the lessons.